הדוברת השנייה, פרופסור סוזן סטון מקרדוזו Law School בישיבה אוניברסיטי, ובשנים האחרונות לשמחתנו גם מבלה איתנו פה הרבה בפקולטה ובכלל בישראל.
So I'm going to apologize, but I'm going to speak in English, so you don't have to hurt your ears. I also want to begin with a personal note, and so I got a phone call about 15 years ago, and my dearest friend in the world called me and said, I heard a rumor. Can you confirm it? I hear that someone in Israel is writing a dissertation about my great-grandfather and his book, the Shara Yosher. Do I know anything about it? And at the time, I don't think I even knew you yet. So I said, I think maybe I'll try to find out. Now, this dissertation on the Shara Yosher aroused excitement within the family. Because surprisingly, despite the singularity of this book, and here I think I will, on Aryeh's advice, my role in this panel, I think, is to address, fittingly for me, those who are not in the Parsha, so to speak, who are not inside this book. It was a kind of singular book because it was virtually the only work produced from within rabbinic circles, even from within the Lithuanian yeshiva circles, that ask such questions as, what is the nature of property and ownership? What is obligation? What is law? And yet there were no full-length academic studies of the book, not even full-length studies, as Shai points out, of the larger Lithuanian movement. Social historians had written about the Lithuanian yeshivot as a response to the Jewish Enlightenment, and specifically the Wissenschaft des Judentums. So if the core idea of German Wissenschaft is the systematic study of a topic, the revealing of the underlying logic of a matter, this is precisely what the Lithuanian yeshivot promised their students to entice them to stay in the yeshiva world. A systematic study of Talmudic concepts using the method of comprehension and logical reflection. There also have been scattered analyses of this method of learning, but all written, to the best of my knowledge, by academics interested in the philosophy of halakha, but not particularly aware of the philosophy of law. One example that I always find startling is Larry Kaplan's otherwise excellent essay on Yashaber Soloveitchik's phenomenological account of the Lithuanian Briska method, which he opens with this question. Why did Rav Soloveitchik choose to analogize halacha to science and not to law? Now, this is a question that could only be asked by someone who is outside the field of law, right? Who is unaware of the history of law as science and how deeply the two were entangled in the 19th century. In short, there were virtually no jurisprudential accounts of the movement and none that placed the movement in conversation with general jurisprudence. So the book we are celebrating tonight, which traverses so gracefully between the terrains of Lithuanian Talmud study and general legal theory, is groundbreaking. Now, as Ron told us in the beginning of the evening, the learning that made this book possible is Shai's study in, I will call it, two yeshivot. Mm-hmm. The Yeshiva of Hebron, right, and the Tel Aviv Law School. Now, unlike Moshe, I have to confess, I have not actually read the Shara Yosher. Right? So my ability to assess Shai's arguments as against the original is extremely limited. What I'd like to highlight, however, are some of the connections between the legal thought of Shkop, as Shai describes them, and broader topics in legal theory that have been a focus at Tel Aviv Law School. And I do so especially because I think Shai's work exemplifies a genuinely new stage in the academic study of Mishnah, made possible by Tel Aviv Law School, where Jewish law is not hermetically sealed off from the general theoretical conversation, and in turn, the new Mishpat Ivri scholarship is shaped by and directly engages that conversation. So to begin with, Tel Aviv Law School put critical legal studies on the map in Israel, and most especially as a mode of doing legal history. Now, the intellectual history of law remains, I think, one of the more exciting forms of legal historical scholarship in the hands of critical legal studies, because it offers a picture of law not only on the books or in action, but rather law in the mind. So in some ways, simultaneously casting off and reclaiming Weber, critical legal studies focused on paradigm shifts in legal thinking or legal consciousness, such as Duncan Kennedy's account of the rise and fall of classical legal thought. Shai seeks in this book to identify a comparable paradigm shift in legal consciousness, inaugurated in the 19th century Lithuanian yeshivot, around the same time as German Pandectism and American classical legal thought, and bearing some resemblance to it. This revolution was a shift to a heightened form of conceptualism, one that could easily be described, as Kennedy described classical legal thought, as an ordering of the whole halachic legal universe. The Lithuanian method sought to reconstruct the ideal law, not individual norms, but rather the legal constructs that underlay the whole of the halakha. And discrete norms, that's rules or cases, became merely the empirical data that could confirm or falsify the legal constructs. Certain features of the Lithuanian method, as I extract from Shai, will seem almost achingly familiar given Tel Aviv Law School's own work on formalism. The idea of legal concepts as facts in the eyes of the legal scientist, and I am now more or less quoting Menny Mautner, as having the underlying structure of human reason and thus knowable scientifically, now quoting Shai Lavi, and as a form of re-enchanted law, to quote Yishai Blank, which insists on the coherence of juridical relationships and depicts law as an ideality. What is particularly interesting about Lithuanian thought, as Shai describes it, is that it hovers, and here I'm going to be looking at something Moshe spoke about, but from a different angle. It hovers between the law as science paradigm of the 19th century and what Shai calls ontological conceptions of halakha, possibly drawn from within the rabbinic tradition. The difference between the two is related to an important question that caught my eye, that of legal change. And so I want to focus on Shai's analysis in Chapter 3 of what he calls the ontological and naturalist aspects of Lithuanian legal thought, and on the ways he argues that it differs from formalism. So imputing ontological conceptions of law to the Talmudic tradition is a commonplace feature of contemporary Jewish studies scholarship. Since Silman put the issue on the table in the context of contrasting the legal theory of the Dead Sea Scrolls sect with that of the early rabbis, scholars of Jewish texts have been debating which text and what thinker held an ontological view of halakha versus a nominalist or value-based view of law, where law serves a purpose outside itself. Most academics conducted this debate with reference to philosophical theories about natural entities and not jurisprudential theories. And thus they failed to consider the role of metaphor in legal thoughts and texts, the sort of law speak that Felix Kohn called transcendental nonsense or legal magic, nor the way legal formalism and ontological views really very closely resemble one another and can be mistaken for one another. Moreover, because they were dealing with the whole of halakha, which includes ritual subjects such as Sabbath and purity laws, as well as conventional legal subjects, there was a tendency to see ontological viewpoints everywhere. Impurity is a real substance in the world like poison, and the Sabbath is holy in and of itself, and to ascribe them to a religious outlook trading on notions of taboo or magic or mystery or will. But unlike the earlier, brisker Lithuanian method, if I understand Shai correctly, the method which Rabbi שקופ pioneered drew a distinction, a very clear and sharp split between משפט עברי, property towards contracts, family law, legal institutions, and ritual law. If Brisk sought coherence among all the parts of the halacha, Rabbi שקופ looked only at משפט עברי, which שקופ held was imminently intelligible, right, and the work of the wisdom of the sages. So precisely because Rabbi שקופ is confining himself to the non-ritual realm, he presents a fascinating test case for reinvestigating the question of halachic ontology. Now, I'm trying in my own way to kind of tease out the building blocks of Shai's view, which is something I very much enjoy doing, so let's hope I get it right. But it seems to me that stimulated by Mayor Dan Cohn's ideas of acoustic separation, Shai makes a very interesting distinction early on and throughout the book between law as conduct regulating versus law as descriptive of legal facts in the world, or statuses, what he calls the is. The is, he argues, are ontological realities, right? Facts as if facts in the physical world. One of the keys to unlocking the method, Shai argues, is keeping this distinction firmly in view. So, for example, is ownership merely the bundle of rights a person has, or is there a concrete relationship between a person and an object, between the owner and the property, apart from the bundle of rights that the legal system may or may not award? Thus, one might have a status, that is, be the owner of property, even though you have no rights of ownership. Similarly, a marriage, perhaps, is it just a bundle of duties and privileges, or is there a concrete, real, or metaphysical connection between husband and wife, that is, a status that's not reducible to the duties and privileges? We're accustomed to old ideas of marriage as a status, an idea, by the way, that seems to be on its way to being revived. But the idea of ownership as an ontological relationship to objects seems odd, although Mayor Dan Cohn, right, has revived it precisely as a way to solve certain puzzles of ownership. Now, Shai claims that the ontological viewpoint differs from formalism as science in two crucial respects. First, the formalist feels constrained by the legal concepts, perhaps as if they are physical realities that cannot be altered. But that constraint comes from the authority of the legal system and the judge's role in it. In principle, change can happen if the legal system is changed. The ontological viewpoint, Shai argues, goes a crucial step further when it views legal constructs as statuses that are built into the fabric of the universe because they are not subject to change. The ontological viewpoint, Shai seems to be arguing, does trade in the end on a generalized religious conception of the identity of the system with God, and maybe we'll have some kind of, this seemed to confuse me a little though, because I'm not entirely certain how it squares with the way in which Rabbi שקופ conceived of משפט העברי. So perhaps we'll leave that for a different conversation. There's a second crucial difference between general 19th century classical legal thought, formalism, and Lithuanian legal thought as developed by שקופ, right, ontology, that Shai points out, which is far trickier and in some sense, I think, may undermine his first point. Shai puts it this way, returning to the distinction he has drawn between conduct regulating laws and laws descriptive of legal facts in the world. Formalism is equally relevant to conduct regulating laws, while the ontological viewpoint is confined to the descriptive laws, to the statuses such as ownership or marriage. This sounds awfully technical, but it seems to be linked to a central and peculiar feature of the Lithuanian method, which is worth noting here. Both formalism and Lithuanian conceptualism seem to trade off a division of labor. In American formalism, it is the split between the legislature and the judiciary. The new formalism popping up all over the legal academy is integrally linked to the justification for an independent judiciary. The new formalism implicitly argues for a distinct mode of legal rationality in the two different realms. Lithuanian conceptualism trades off a far more radical division of labor, while formalism presupposes the eventual application of the core legal concepts to a set of facts and ultimately to a decision involving the lives of real people. The application of the law, articulating who owed what to whom and who was or was not married or divorced, seems to have been of no real interest at all to the Lithuanian school. The Lithuanian school's energy was entirely directed to reconstructing an ideal law separate and apart from the normative realm of conduct as the defining aspect of the method. Now, the distinction between an ideal theoretical law and law to be applied exists in earlier layers of the rabbinic tradition, but it is enormously intensified in Lithuanian lamdas. This utterly non-instrumental approach to law became elevated into a theology of its own, a kind of pure world of law that is uncontaminated by societal needs or moral questions. If I understand Shai correctly, this may be an effect or consequence of the method, right, from the splitting off of the is from the conduct regulating aspects of law, direct duties to act or court orders to act, and not necessarily even its initial aim. In the end, though, the ontological viewpoint doesn't seem to have any practical effect and does not operate as a constraint on change on the ground. Finally, 19th century formalism and the Lithuanian ethos, I think, shared another feature that bears on the question of legal change. Langdell's orthodoxy was fully compatible with historical legal development. Law progresses, right? Both he and Beale and others readily said. They ascribed legal change to the historical situatedness of the individual judge in society. This idea of a situated individual confronting the legal tradition has always seemed to me to be a deep part of the Lithuanian method, certainly as it's later understood. Now, if it is the case that it had from its beginning a kind of connection to Wissenschaft, that means that really from the beginning there was this notion, right, of requiring the student to critically reflect on the system and use his subjective logic, right? That already opens up a space for the individual vis-a-vis the tradition. This is amplified in the idea of the chidush, right, which emerges so importantly, right? Legal innovation as a sine qua non of legal analysis. And by the time we get to J.B. Soloveitchik's reconstruction of the philosophy of the Briska method, the creative and situated subjective individual confronting the tradition is a cornerstone of his religious philosophy. I began my talk by singling out how this marvelous book is emblematic of a sea change in the academic study of Mishpat Avri, due in no small part to the interests and, I think, ethos of Tel Aviv Law School. I'd like to close with a page of history on Mishpat Avri as an academic field and, a kind of hopeful glimpse of the future. In the 1930s, Rabbi Yechiel Weinberg, the Sridei Eish, a Lithuanian-trained rabbi, though something of a maverick, eulogized his teacher as follows: "When we shall be worthy of having a true Hebrew science, the Hebrew scientists will recognize and understand the value of the great ideas spread throughout his books. The new Hebrew science, and in particular the field of משפט העברי, can learn much Torah and wisdom from his magnificent works if it knows how to retrieve the original ideas from the give and take of the Talmudic discussion, which Rav Epstein made the external superficial framework for his chidushim. Here and there, brilliant ideas and new definitions of legal terms and concepts shine. Their scientific value is immeasurable. The one academic scholar of משפט העברי who has always reminded me of this particular challenge, and who is a lifelong friend and correspondent of the Sridei Eish, was Shmuel Atlas, right? A student of the Lithuanian method, and I asked Moshe, and he says, yes, the Chels Yeshiva, right, of Rabbi Shkop, right? Who played out his career in the United States at Hebrew Union College, a reform institution. Atlas's work always struck me as utterly brilliant, as a brilliant attempt to identify a kind of deep structure in Jewish legal thought and to show that texts from different layers or even periods and even different genres could be made coherent and intelligible as expressions of a distinct legal or political or moral conception. Now, this is standard legal practice. Yet precisely because it is also the method of the yeshiva, it has for too long, I think, been viewed as the exact opposite of a Jewish science, and especially within academic Jewish studies. All this is changing as legal theory has come to penetrate the consciousness of other disciplines, and I think this is a change that the Tel Aviv Law School has played a crucial role in bringing about. So, back to Shine. The Sridei Eish did not think the Lithuanians had already transformed halacha into a legal science. They held out a hope for a legal science to emerge from their beginnings. I take it that this is Shai's next project, to translate some of the insights of the Lithuanians into Western legal thought, along the lines in some ways of Mayor Dan Cohn's interjection into property law, and engage in a mutually fruitful discourse. So, here's to the next book party.
תודה רבה.